an employee prove that a covenant or a non-compete agreement is an excessive hardship on them and therefore should not be considered reasonable?
This is Avi Scott. When you ask a question like how does an employee prove, the language of the question suggests that you're already in court. And I think that that's a legitimate way of looking at that particular question, because the employer who required this agreement that appears to be excessive probably won't back off of it because it's the employer's contract. So let's focus on that question from the perspective of being in court. I think, if you just follow up on some of the themes that all three speakers have spoken about, for example, if the restrictions are disproportionate to the nature of the employee's job, or if the restrictions are disproportionate to the amount of compensation that the employee got during the term of employment, or if the restrictions are disproportionate to the employer's needs, you're in a position to say that the contract imposes too much of a restriction. So, for example, if you have a non-competition agreement which says you can't compete in the area of, selling this type of product, when, or to put it in terms that a judge, in a case that I was involved in, put it recently, the plaintiff in that case was attempting to restrict the employee from selling any type of product in a particular field. And we were arguing that the competition between the former employer and the current employer only involved a finite set of products, and the current employer sold, a much larger set of products. And the judge said, well, this is like an employee who works in an auto parts store. You're saying you can't work in the auto parts store when all you do is sell transmissions. And the defendant is saying, I should be restricted from transmissions and nothing else. So that was a case where there was a disproportionate restriction against an employee who's only selling one product for the prior employer. Disproportionate situation is, the Jimmy John's case that we've all talked about to an extent, where employees are making minimum wage or slightly beyond that, and the employer is saying, well, no, you can't work for another sandwich store. It's a tough sell to try to convince a judge that, you're going to be harmed if someone switches jobs to a different sandwich store. So that's what I would focus on, a real disparity between what the employer needs and what the employee is getting paid, or what the employee does, or which product the employee works with.